Welcome to All the Way Up podcast by Jeffrey Mensah. This is the Bar and Beyond series, a platform where we host insightful conversations that push growth, drive ambition, and shape perspectives of young lawyers. Hi, lovely listeners and viewers. Welcome to this episode of the All the Way Up podcast. I'm excited, delighted to be sitting across this wonderful guest. She's a great woman by all standards. I was privileged to have been lectured by her when I was at the Ghana School of Law. She, over the years, has made her impact felt in both the legal profession and the legal markets globally and locally. She is managing partner of the law firm Okudzeto Associates. Ladies and gentlemen, my guest for today, Mrs. Victoria Barth. So, Mrs. Barth, welcome to the podcast.
Thank you, and warm greetings to all your wonderful
Thank you as well. And thank you for agreeing to have this conversation as well. I kept telling myself this episode has been a long time coming.
Yes, since last year.
And it's good that today we finally get to sit across each other to have this conversation. And so, Mrs. Barth, you were called to the bar in 2002.
Yes.
And per my arithmetic, that would make you 24 years at the bar this year.
22.
22 years at the bar.
Yes.
Congratulations.
Thank you.
Congratulations. I think that means I was probably about 8 or 9 years old when you started.
Are you trying to make me feel older?
It just goes to show how honored I am that we get to have this conversation. And also, my research tells me that you were ranked in Band 2 for dispute resolution in Ghana by the Chamber and Partners Global Guide 2024.
Yes.
Congratulations on that as well.
Thank you.
And you are now a member also of the International Court of Arbitration.
Of the ICC.
Yes. For the period 2024 to
2027. It's always a 3-year mandate.
Okay.
So a bit about Chambers Global. They are a ranking organization that collects data or information from peers. So, there are some ranking organizations for law firms where you go and pay money to be ranked. Okay, so Chambers is not like that. They do their due diligence. They contact law firms, other lawyers in the same country, and also client reviews to find out lawyers who have distinguished themselves in their areas of practice. And depending on your expertise and performance, they then put you in bands. So band 1 is the highest, band 2 then follows, I think, up to band 4. Also, they do it for individuals as well as law firms. And so I had the privilege of being ranked for the first time in 2023 and then in 2024 for dispute resolution. Because if you know what I do, I'm primarily in the litigation space.
Now that I have an understanding of it, I think my congratulations has to be louder. Congratulations once again. Yes.
Thank you. And then the International Court of Arbitration, that's the International Chamber of Commerce Court. It's not a court in the judicial sense of the term, but its role is to, among other things, scrutinize awards administered by the ICC, which is... and the International Court of Arbitration is, I dare say, the world's leading arbitral institution. So what they do is they have member countries, and Ghana happens to be one of them. And each country has a number of representatives that it can nominate to serve on the court for a particular mandate. As you said, mine is 2024 to 2027. So Ghana has 2 seats. And Mr. Kizito Beyu and I are the 2 who were nominated. And then the ICC has a World Council that votes. So your national committee nominates, and then they vote. And they accept you. So as of 1st July, we began our term as members. And so they have sessions. I hope I'm not taking too much time with this, virtual and in-person sessions. And they work through committees as well as the plenary. And what happens is that they have a very solid secretariat that receives requests for arbitration and does all the administrative work that it takes from the time that the request comes to the tribunal being composed and carrying out the arbitral proceedings. And then when they have a draft award, that is when the court comes in. Because the committee is set up to vet the award, to produce a report on it for the consideration of the arbitral tribunal, to ensure that the award that has come out, adheres to the ICC standard and that it will hold up when it comes to enforcing it. So as it were, giving it more credibility as opposed to maybe going for arbitration with another institution. So in a nutshell, that is...
In true, they'll say
Yes,
and it sounds like a lot of work, and so all the very best in this portfolio.
Yes.
And so we'll go to your educational background briefly.
Yes.
You attended the SOS Herman Minor International College.
Yes.
You later on went to the University of Southampton for LLB, and then back to Ghana School of Law, and then the story unfolds.
So before SOS, I went to Infantsman Girls Secondary School in Salt Pond for 3 years. So let me not forget my...
Very important.
Yes.
Very important.
Yes, it's part of who
that
I am.
alliance must be made known.
Yes.
And so can you tell us briefly how you settled on the intention to become a lawyer, having regard to your educational background from Infantsman all through? What were the influences? What informed it? Was it easy settling on, I want to be a lawyer? Because most of us youngsters now find trouble settling on something. I know at some point in time I wanted to be a pilot. And then I abandoned it very easy.
Yeah.
So what was your story?
I perhaps I'll disappoint you because I didn't have any particular lawyer figure that I was looking to. It's more of TV characters. I loved watching TV a lot, and especially if there was drama or programs in which there were courtroom scenes. I was spellbound by advocates on their feet.
Wow.
And while I didn't know that was what I wanted to do, the whole process of interrogating evidence, I found it quite appealing. I found myself reading books by John Grisham, a lot of which had to do with the law. And so as an arts student, reading was a passion for me. And I just gravitated towards what were my strengths. And, growing up, unlike today, where there are so many different careers to look at, you're either going to be a lawyer or a medical doctor or an accountant or that. And I didn't see myself in the science direction. And when I looked at the arts area, the only thing that really called out to me was law. So I applied for law. I got some universities that accepted me for law, but then when I was about to accept, my family members in the UK said that Nottingham was too far to visit me frequently. So I accepted Southampton, which had offered me economics. But I had expressed to an uncle of mine when I got there that I wish they were accepting me for law because I knew economics was going to involve mathematics at a certain stage. And while I had excelled in economics for A-level, I wasn't dreaming of doing anything intimate with math. Yes. So fortunately for me, when I got onto campus and I made the inquiry, they just switched me to the So I did the LLB. I followed up with 1 year the legal practitioner's course for solicitors. England has a dichotomy. And I came to Ghana. I didn't do the post-school. I had to do the full 2 years, which when I was admitted, those were the conditions that I was given.
Wow.
Initially, I was disappointed, but I look back and I'm grateful for it because I feel so much a part of my cohorts because I got to spend 2 years with them as opposed to 3 months.
3 months,
Yes, and it gave me the opportunity also to really familiarize myself with Ghanaian cases. Something that I would not have been able to do most likely on a 3-month post-call. Because, yes.
I was actually going to ask how your approach was switching from the UK cases to Ghana. But I think that 2-year period
Yes.
just sums it up and answers that question. Mm-hmm. Entering into the legal profession, being called to the bar 2002. What were your expectations of the profession? I mean, for some people, it's hey, the cash is coming. But for you, what was your expectation of the profession?
I think prior to being enrolled, I had done internships with the late Papa Datsun from Benjamin and as associates in Kumasi. And what I had picked up from there was that, one had to work very, very hard. And then eventually you would come into the money.
Yeah.
So I had realistic expectations. I wasn't expecting to get rich overnight. My expectation was that I would have the opportunity to build my knowledge base and grow my expertise and hopefully make my mark in the profession.
Okay.
So while the financial rewards were motivation, it wasn't something that was clouding my judgment right at the onset.
I like when you say realistic expectations.
Yes.
I think it's very important because I think a good number of us young lawyers, law school, you are in a hurry to come into the profession because I come in to watch it, and so you are looking forward to the money. But then when you mention having realistic expectations, I think that's something that we all need to put in our pockets as we enter into the profession for the young ones coming up. You did some time at the Attorney General's Department,
yes,
Civil Division.
Yes.
Can you touch on that briefly? What was that time like?
Would I even say was a civil division, because I ended up most of my days were spent at the regional tribunal.
Okay.
Working with my boss for late Miss Ellen Kwaukume. She was the chief state attorney then in Kumasi.
Okay.
And I dealt, apart from desk work, like writing opinions on dockets referred by the police.
Yeah.
Mainly, I found myself at the regional tribunal dealing with narcotic cases. Of course, I was at the pupil level.
Okay.
And pupils don't have rights of audience.
Yeah.
But I would appear with my senior. I would have done some research. And it was a period where I became aware of some of the failings of our society, because most of the accused persons were young men between 18 and 25. And it was quite a depressing period for me, that aspect of my work, because, most of them came, you could tell they were from dysfunctional homes, had not really had much of an option, as in not ending up on that path. Yeah. They were unrepresented. They would have been on remand for months on end. Yeah. And the only light at the end of the tunnel for them was to plead guilty and face a mandatory 10-year sentence. Wow. It's one of the things that, as I speak to you, perhaps when that law is being considered for review, the sentencing regime, one has to really look at it. I do not encourage drug use in any way. I mean, it's a canker. But I think that a significant number of young people who have gone to jail for those offenses, for that 10-year minimum sentence, we've done them a disservice, because there's little to no room for rehabilitation, which is what they really needed at that point. I think also my time at the AGs showed me that I really didn't have the heart for criminal cases. Yes, because there's another gentleman who was sentenced for slashing his former girlfriend's face. And, I found myself crying for him when the sentence if I had to work there, of course, I know myself, I would develop the stamina to, manage my emotions. But at that point, I said, no, once I finish, this is not for me.
The prosecutor was crying for the accused person.
It was awful. But I guess
that's interesting, Mr. Barth. I'll then ask, so what then were the lessons of that phase? I mean, you shared a very deep reflection. But as a pupil, what would you say were those lessons that that period taught you?
Well, I'd say that it made me know where my true passion lies. It also made me aware of how privileged I was. The options and opportunities that one of the things that is striking is that all those years ago, the AGs was quite under-resourced. And I know that some of the problems still persist. There were days my boss would have to buy a ribbon for the typewriter with her own personal money because funding had not come through.
Right.
I want to believe that that has changed now, but I know that, lawyers working at the AGs have all kinds of constraints and they really put in their best. I saw people who really work hard, in the AGs department, as though they were running their own firms. But for me, the deciding factor was that I was clearly convinced that I belonged to civil litigation.
And so after your time at the Attorney General's, then there's a switch to Okudzeto Associates.
Yes.
Is that correct?
Yes. So there's an interesting story there. Before I grew up in Kumasi, hence starting my pupillage in Kumasi or having internships in Kumasi. But I met a man called Barth in Kumasi who was looking to move to Accra, to advance his prospects where he was working at the time. And before I left for Kumasi, Justice Nene Amegache had approached me because he taught advocacy and legal ethics at the law school. And he took an interest in me after I had done my moots in the advocacy session. So the day we had the legal year service after the course, I said, "Lady, won't you come?" And I was that fortunate for him to actually invite me to join the firm. I said, "Oh, I'm going to Kumasi." He said, "What is in Kumasi?" So coincidentally, when I finished my pupillage, it so happened that, our future was looking towards Accra. And when I contacted him, happily, the offer was still on the table. And so I came in for some informal interview. And that was the beginning of my life here at Okudzeto Associates. Nice. It was an easy decision for me to transition here because I looked at the person of Justice Amegache and what he represented. And I thought that if these are his values, I'm talking about a man of integrity and, diligence and competence, all those things I gathered from how he handled his sessions as a lecturer and his approach to teaching. And he's also an individual who's very approachable and receptive of the opinions of others, irrespective of their age at the bar. That was something that was very appealing to me to have in a boss. And I also looked at where his career had taken him, and I thought this would be somebody good to have as my boss, to mentor me and to guide me. So that was attractive for me. And also the Christian factor, because this firm doesn't shy away from indicating that it is a Christian law firm. So all those things really resonated with me.
Right. Justice Nene Amegache, I mean, you shared some of your encounters with him, how he influenced your decision to be with Okudzeto and Partners. I quite recall that in 2012, when I started LLB at the University of Ghana, during our Law Week celebration, he happened to be the guest of honor as the president of the bar at the time. And I recall his advice to us was, don't become a head notes lawyer. And so it's interesting. He was encouraging us to read the full cases. And it was during that time that some of us were struggling to get through a whole case, And so it's interesting that you then share how he's impacted your life. Okudzeto and Associates. In there is the name of the founder.
Yes.
The great Uncle Sam. Can you share any of your fond memories, encounters, how he's impacted your life as well?
So Uncle Sam was also teaching advocacy and legal ethics. In fact, he and Justice Amegache were alternating. So I got to know him. I knew him because I attended Rich Church and I'll see him there, but I got to know him better as my lecturer. And he was a father, a disciplinarian, a man who speaks his mind, but at the same time, he was such a force to reckon with And of course, his name in the country, no one needed to tell me what he represented or the kind of firm that he had built together with those who had come along. So with Uncle Sam, when I joined the firm, he's the kind of person who takes an interest, in your... Uncle Sam will walk into the office and notice that you have a different hairstyle. He's that kind of person, So he will work with you. He will be very forthright about the quality of your work. I mean, we all laugh about it. Use your head, that kind of person. But you have to know that it's not meant to demean you.
Right.
He means well. He feels strongly about the work.
Yeah.
He wants to shake you out of your slumber and get you to really attack what it is you are doing. But with both he and Mr. Megache is the level of detail to attention, and the resolve not to compromise on quality for a client. And then also, while we are working for financial rewards, that's not the primary objective. Justice being the first thing, obtaining that for your client, and sometimes even declining to represent the client when it means that you'll be undermining the administration of justice. One thing that I strongly, learned from the two.
Those are very powerful marks. I believe they've left on you.
Yes.
Sam Okudzeto Associates, you joined the firm, and you've been there to this very point where you are now managing partner. All right. I normally use the analogy of sports. So take a player like Wayne Rooney. Okay, he started at Manchester United, played his entire career there, and retired. All right. Others will start with teams, change along the line. What informed your stability, your decision to stay with Sam Okudzeto and Associates from the very start till now?
Let me say that I think a lot of it has to do with my personality. And also what my objectives for the profession have been, because it started, when I started, I thought, I'll just do 5 years with this firm and go into corporate practice. But I always say I caught a certain bug and I've not been able to recover from it, yes, to date. So naturally, I am a very loyal person. When I commit to a task or a relationship, that's it. I'm logged in. I'll have to have a very good reason to back out.
Okay.
And when I caught the bug after my first 5 years, 10 years, and I finally realized, look, litigation, it is trial lawyer, my blood through and through. For me, other law firms are no different in terms of the challenges they have, or, perhaps the opportunities that would be open to me. And so while with every organization that you work with, there are things that you would want to see improve or change. I was not so aggrieved to the point of feeling that I need to leave. Okay. I wasn't starved of opportunity or new adventures such that I felt I wanted to be in a different environment. But another major consideration was the fact that I started having my children very early on in my career. Okay. And I found that I was in a very supportive and safe space. So I had 4 children, and then the age of 6 at the time. My oldest was just getting to 6. And I was able to bring the first 2 every day after school. They would come and do homework with me. Mr. Justice Amegache in particular was very encouraging of that, because he felt that if I could cater for them, then I would have the free mind to subsequently stay in and, finish what I had to do. Yeah. I remember when I joined this firm, we were not even meant to be taking files home. But of course, with the advent of WhatsApp and all sorts where clients can reach you you couldn't sustain that practice. So the firm was very supportive of me in managing my work-life balance, making time for my children. And I think that was a very huge selling point because I needed that stability. And at the same time, they were interested in my professional development and exposure.
Okay.
Yes. So I would get the opportunity. I mean, for one thing, we have a deliberate strategy to ensure that all our lawyers participate in matters affecting the bar. So one of the benefits of working here is that every year, so long as, yes, you attend the bar conference, unless for some budgetary constraints we have to choose. But then since I joined, that's been the practice.
Right.
And likewise with some international conferences that when you prove yourself, you get the opportunity to attend. So I looked at all those things. I looked at where I wanted my career to progress to. I wanted to be a formidable litigator, and I didn't see any other better seniors to be working with than Justice Amegache and Mr. Okudzeto. And I thought that I was getting a flavor of working on cases that I would be seeking to chase elsewhere. So maybe I'm not ambitious enough. That's one way somebody would look at it. But I think I have been satisfied and I have been happy to compromise on certain aspects because it meant that I was making room for other areas of my life, which I would probably not have the opportunity to do if I moved elsewhere. Yes. And Okudzeto Associates has been like family to me. And it's always difficult to part
from family.
Yes.
Yes, that's wonderful. Ms. Bago, backtrack a bit. You made mention that at a point you were settled that look, it's litigation I want to do. Okay. Was that still informed by your childhood encounters with John Grisham and all these court-based drama, or along the line, certain things reinforced that choice of the practice area?
I think I realized that I have a natural flair for it, or let me say that it's a gift. Because you see, some people dream about, I dream about traveling, all those things, but I go to bed consumed with the different ways in which I'm going to ask a question.
Wow.
I'm standing in the shower and I get a revelation about how I would order the chronology of, and I'm so excited.
Wow.
You understand? So when you begin to find that you have such a passion for something that another person considers so boring, and I mean, it's not always exciting going to our courtrooms. The delays, the challenges, but in spite of all that, I could have a very bad day. I could lose a case successively at different levels when I know that I should be winning that case. And I come and all I need is for a process to land on my table, which contains what I think is, rubbish, for lack of a better word. Yeah. And it's like being possessed. I am just...
The energy just comes out.
Yes, and I have to do something about it. So... that's the bug that I'm talking about. But I realize that I have a knack for what I do. I come at it differently. It's getting better over the years, if I dare say so, on my own behalf. But I realize that when I read a brief, the kind of things that will be clear to me, that yes, the revelation is the word that I will use. And the strategies that I would deploy.
Yeah.
Sometimes I marvel, I look back and I'm like, wow. So I began to appreciate, because I mean, there were times when there were pressures. My husband, for instance, was encouraging me to go more into transactions. Yes, they may take a while to close, but there's certainty, unlike litigation, especially if it's land years on end, you are in court. Yeah. But I realized that while I didn't care if it meant I would be sitting in some, shack of a court, or walking across from Cocoa Affairs to wherever, or even the money was not the kind of money that a transaction lawyer.
You touched on some of the guiding principles or the pillars that have defined your practice. You make mention of diligence,
yes,
leveraging on your strengths. Are there others that over the years have stood out to you?
Yes, I mean, first of all, it starts with honesty. Right from the inception of every engagement, you have to ask yourself certain questions.
Yeah.
You know, this thing that I'm doing, is it legal? Is it ethical?
Okay.
Of course, there's the question of, is it going to yield financial returns for the organization, because we'll run bankrupt. Yeah. Even though there's a deliberate strategy also to do some pro bono cases. But for me, the principle is that once I touch something, I must do it, and I must do it well. So if I take on a case, I know that the person has a chance of success, right from the filing to updating, to researching, to everything, has to be done, and done with care. That means that if I'm generating a process, it is formatted. There are no typos. If I can help it, it is well researched. I mean, it's being filed on time. My team laughs at me because I'm a last minute person. But what I do is I surround myself with people who meet deadlines. And so they keep me exactly. So, diligence, hard work, tenacity. In fact, you can't do what I do if you're not tenacious, because you will encounter obstacles. Sometimes even your own clients will be an obstacle because they are not paying you. But once I said I'm doing something, unless the client has lost confidence in me or is disrespecting me, sometimes regardless of the fact that payment is not coming, I must end it. I must end it well.
Right.
So the commitment is important. You also have to be able to exercise judgment, because part of what we do is reading people.
Yeah.
Reading the judge, reading your friend on the other side, reading the person in the box. And then there's the human aspect. Of course, the reason why I can take a case to completion when I'm not being paid is because I care about what it is the subject matter is and what it means for the person who, for some challenging reason or the other, is just not forthcoming with payment. So that also comes in. Self-control, because sometimes you may just lose it, when you go to court or when you are served with the process. So I've had to learn how to manage my emotions. I do not always succeed, but I'm a work in progress. Yes. And then being open to, the use of technology and, other means of expediting and being more efficient with your work, but definitely teamwork as well. Yes, because you don't know it all. No one person is the repository of all knowledge, especially when it comes to the law.
Right.
And so it's important to leverage on the strengths of your team as well.
Ms. Barth, what has been your approach to career growth?
Okay. So for me, it's in this firm, it had to do with coming in as a junior associate, and partner. And I guess, as I said, when I said I had realistic expectations, I'm the kind of person, mine is just do your job, do it well, and you rise. But then, of course, you have to be deliberate about training, making sure that, so I said I'm a trial lawyer. Almost every training that is organized locally by the bar, which enhances my growth as an advocate, I have tried to participate in it. Of course, I've gotten a lot of training in-house, but I've also built relationships. So almost every lawyer that I've had the opportunity to handle a case with, if you're on the other side, and especially the ones who have distinguished themselves, I maintain contact. So people like Thaddeus, I harass their lives. Thaddeus, sorry, is one of them. Justice Kulendi, before he went to the bench, was a respected senior and good friend. Even members of the bench, there are several justices. Justice Mafosan of blessed memory, somebody I would pick my phone and call, say, Dennis, I will come after you. Of course, I'll do it respectfully. I'll make sure that there's no conflict issues.
Yeah.
Remember, I talked about honesty, that's key. But one thing I realized is if I see you and I admire your career trajectory and what you represent, I'm definitely going to nurture a relationship with you and find out how I can improve upon myself in what I'm doing. So in my particular personal journey, there's not been a lot of acquisition of certificates, masters upon masters. Not that it is not important, it is in my future.
Right.
But it's been more of gaining experience in the school of life.
Right.
So
right.
yes, that's what I have been doing, and making sure that I maximize whatever opportunities that are readily available to me. Yes.
Okay.
I'm not sure if I've answered your
You have, Ms. Barth, you have, and I'm very grateful for the response. Partnership in a law firm, all right? Some Okudzeto and Associates, we use that as a case study. From partner, hopefully, you become a managing partner. There can only be one managing partner
at a time.
And so we'll say the pinnacle really would be the partnership level. What, in your view, would get someone promoted to partner level? What are some of the traits that one must have? Partner in a law firm, of course. What are some of the traits? What should you be able to do for us to say, look, we can entrust the portfolio of a partner to this lawyer?
I mean, there are the typical things. Some people look at your ability to bring in clients, what you'd call a rainmaker per se.
Okay.
But in whatever scenario you look at it, that person must exhibit leadership qualities. And it starts with basic leadership, as in being able to guide junior lawyers, on a task that is assigned to that person, either in the capacity of a team lead or as a senior member of a team or a more senior member of a team. So somebody who is able, in our scenario, I am in the litigation practice group. So if I was looking for a litigation partner, the early signs would be someone who can handle a matter end to end with minimum or no supervision. It's not just about intelligence, but it's also about a person who takes responsibility and ownership of what is assigned to them and the people that they are working with. How is that person able to resolve conflict? Because you are dealing with people management. You must have some kind of business acumen or the ability also to understand the business behind the practice. Because yes, we are engaging with clients and we're doing the work, but there's a management of finances, there's the administration, making sure that people are paid, welfare, all those things. So does this person understand the business and where the firm is headed or should be headed? Do they take an interest in that? Are they a good representative of your firm? Do they have the potential to take the firm into new areas of practice or growth? Do they have a network of relationships that the firm can leverage on, not just in terms of business, but in terms of professional development and exposure? Those are some of the things that one would look at in deciding on selecting a partner. And then, of course, for our particular model, if you've observed some Okudzeto Associates, we've never taken partners from outside. In the future, we may consider that, because sometimes that is the quickest way to make inroads into a new area of practice. But so far, we like the organic growth. So you would also reward somebody who has served for a number of years. So, but you do all that bearing in mind that, long service does not necessarily equate to, competence and all that. So it's a whole lot of things that you look at, and also how that person being a partner will feed into your strategic objectives for a particular time frame.
So, Mrs. Barth, with your story, you start out as an associate, I believe.
Well, I came in as a
junior,
pupil.
a pupil.
Actually, yes. When you join this firm, you do your pupillage again.
So you started out as a pupil.
Yes.
Climbed up junior associate.
Yes.
Associate.
Yes.
Then partner.
Yes.
Then
I wasn't given title of senior associate till I became partner.
Right. Right. And so for your career trajectory or climb within the firm, would you say you were groomed, either informally, formally, and what did that grooming look like for you?
I would say I was definitely groomed, and I wasn't the only one. It's just the nature of the leadership style here. Someone would call it micromanaging.
Okay.
And in those days when we were following Justice Amegache to court, people used to tease us locomotive because it would be like a mother duck and
the young
ducklings. But it was for us to observe best practice. I had the kind of seniors who ensured that I didn't go anywhere unprepared. You are not ambushed. Right. As it were, you are handed a brief or to go to court or to go for a meeting and you don't have full instructions and you don't understand. No, we don't do that because we care about our reputation and our brand. So my bosses, my immediate seniors and my ultimate boss at the time, Justice Amegache, who I interfaced with more, were very particular. I mean, if you produced work, it went through a hierarchy.
Right. And
your attention was drawn to making sure that that work was of a certain standard before a senior of a certain level would look at it. If it had to do with your appearance, there's a standard. You don't leave some Okudzeto Associates and go to court in anything other than black or dark navy suits. If you have to have your bib and gown and your robe, everything's on point. Yeah. You're not wearing sandals or no, those things don't happen here. So as far as dress code for court, of course, we teach ethics and advocacy. A number of us, so those things are in place. Adhering to ethical standards, it's hammered into you, and then also, for instance, when I talk about, you are talking about grooming for partnership, but for me, it was beyond just the partnership role, but for leadership generally in the profession. So, Justice Amegache, for instance, after dragging you to conference, your services are volunteered for various committees. So long as there's a need, where's my girl or my junior here can? Then you are thrown in there. They inculcated a culture of service and availing yourself for work at the bar. It wasn't just that. We would be carted off, not carted, carried to Amasaman every last Friday of the month at the time for mediation, so that we would go and assist.
Sessions.
Yes, because he was, as I said, big on anything to do with alternative dispute resolution. Yes. Also, when you have a leader who knows what your strengths are, and then they guide you that, there's this course, that course, it will be good for you. Follow it. I mean, how did I end up teaching at the law school? It was because Justice Amegache and Mr. Okudzeto, Uncle Sam, decided that, they saw in me a lecturer. I thought that teaching, in fact, teaching my own children, I thought it was just by virtue of the fact that I had given birth to them. I didn't consider myself a good teacher. I didn't think I should be teaching anybody anything. But it's one of the things that I love doing so much now. And it takes somebody who has a foresight and who sees your future, to hold your hand, as it were, and take you onto that path. So many things. I mean, ICC, how did I get there? Because he was involved with arbitration and he would drag you along, look at this, follow me here, do this research for me, do that for me. And in the process, you discover new areas that you would otherwise not have selected for yourself. So, I was and have been fortunate in terms of my leaders who have been mentors, they've been coaches, and they have guided me on choices that have ensure that I am where I am today. And you see, there is also room for you to spread your wings. So, for instance, I serve on the board of a bank. These are opportunities that come, and the firm is very supportive because there are learnings from there also that you bring into the work that you do here.
That makes sense.
And then for your individual, development, they recognize that is also important. So yes.
So you're now managing partner of the firm. You've served for how many years?
I have been since 2018.
Since 2018.
Yes.
I just want to take you back into history.
Yes.
When you were informed that, look, Mrs. Barth, we are handing over the reins of management to you. What was the feeling like? What was your mindset like? How did you prepare to start work as managing partner?
Well, let's just say it was a daunting prospect. Somehow, I've had a bit of good luck, Jonathan stroke in this firm, So in this firm, in my teaching life as well, because I've sort of stepped into Justice Amegache's shoes as he's moving on to something else. About a year or two before, and this is where I talk about visionary leaders. He had introduced the role of a deputy managing partner, and it was part of, as it were, succession planning. You groom associates into partners, and then you must also have somebody in the pipeline to take over the managing role. And so I was serving as his deputy. But at the time, I was relaxed. Most of the management decisions, I was happy to just glide along and let him work things out himself. So here I was thinking, oh my goodness, this man is completely leaving the scene. And we all know the history of law firms that are started by individuals, as ours was. You didn't wake up dreaming that you would be a managing partner while Mr. Okudzeto is still sitting in his firm. But we've come far. We've learned about emerging trends, and also the fact that if this firm has to thrive and go many years into the future, then it means that other members of the firm must have a sense of ownership, and a say in its future. I knew that even though it was a challenging thing, I didn't come here with a manager's hat. You understand? I hadn't particularly taken a keen interest in the details of the accounts of the firm, even though I was a partner before. And these are things you have to be involved in, the business plans, strategy, and all that. But I knew that Uncle Sam was still around. There were other partners also competent. I wasn't going to do this on my own. And fortunately, Justice Amegache was just going to be across the road if I had difficulties. But it was a period for me to learn and grow. And of course, before I became a partner, I would have had to demonstrate some managerial ability to manage people and all that. So I learned, I applied myself, I worked together with the partners board, and we are where we are today, still growing. Yes.
Powerful. Okudzeto Associates, 50 years.
Yes.
And counting. Is an ongoing success story. You are the managing partner. What would you say have been some of the challenges that since 2018, leadership challenges that since 2018 you've encountered, and how have you gone about them? More and more of the youngsters are setting up now. Just last week, I saw a logo on the status of a junior colleague of mine. I said, what was this? They said, I've set up. And so we need to learn quickly leadership and these principles. And so for you, those challenges, how have you surmounted them?
I think one of them would be talent retention. First of all, identifying the right talent and then being able to hold on to. there was a particular period a few years ago where we had sort of like an exodus of the middle belt.
Wow.
So people who have been with you between 4 to 6 years, who have really imbibed the culture of the firm and are ready to be senior associates, are fairly independently working on their own, that you can lean on. And suddenly everybody was going to school.
Wow.
You see. So that posed a challenge, because then on various teams, you had a partner so many years up there, and then all the associates were 4 years and under. It was a challenging period, but it also taught us a few things. And of course, there were also some people who left not just because they were going to school, but they had concerns about their career progression or compensation. But what we learned from that was to engage. Me personally, I learned to appreciate that, one, not everybody who comes into a firm is there to stay forever. So you have to have a plan and a strategy to get out of that person what you can in the 2 or 3 years that they are there. Is it skills transfer, knowledge transfer that they can pass on, so that when they are leaving, there isn't such a gap, because you have already anticipated it and you've raised someone there. Are people going to school? Let's have that open conversation right at the onset or over the years. So we plan and we don't have everybody leaving at the same time, as much as you can. And also holding on to, or even having them return after they've gone to school. There has to be something that makes them happy to return and incentivized to stay. So that balance. Another challenge, again, is balancing, practice and management of the day-to-day affairs of the company, the firm. Because I'm still very, very active in my practice. And, sometimes finding the right balance to make sure that you are able to give clients enough of your time and also attend to the business of the firm. That can be challenging. But then you learn to delegate. You learn to rely on systems that can help you better manage and take decisions, so that you don't collapse, or you also do not compromise so much of one of your duties at the expense of the other. And then, of course, change. I think managing change. It could be change in our location as we moved. It can be change in the kind of work or change in direction, strategic goals and all that. And you find that some people will resist it. But that is when your ability to communicate effectively has to come in, and carrying people along and dealing with those who will not pull their weight. So discipline and conflict resolution, all those can be leadership issues. But once you are able to communicate your vision well and carry people along and they buy into it, you always somehow, water finds its level.
I'm glad you mentioned the business of running a firm and the challenges that it poses, trying to strike that balance. Now, having regard to the rules that govern the profession, the rules against touting and whatnot, you realize that it's a business. And like every business, people need to know what you are doing. You need to be able to market your services in one way or another. And it brings me to the theme of branding as a lawyer. How would you say, from your experience, you have managed to brand yourself properly, get the word out there that, look, this is who I am, these are my expertise, and I can handle your case for you successfully, all right, within the confines of our regulation, the rules that govern our legal profession? How have you gone about it, in a sense?
So I have never personally marketed myself, as it were. I mean, if you even look carefully, you see that I've only recently become very active on LinkedIn. I've been on there for years. But again, it's one of the, if I may say, New Year resolutions, because a lot of people kept complaining, we don't find you on LinkedIn. And with where I'm headed now, it's important that I stay relevant in some of those spaces. But when we started, you referred to something like my ranking by Chambers and Partners Global.
Yeah.
There are legitimate avenues for lawyers to be recognized. But I'll come back to Chambers. I think the Akans have a proverb that's Anypankasa.
Okay.
You know, or Adipaneton.
Yes.
There's that aspect where you can distinguish yourself so much that your work and your reputation precedes you. So for some lawyers that I know, and in all humility, I would count myself as one of them, my visibility has been an account of my encounter with people that I've had the opportunity to work with.
Right.
They are the ones who market me. It may be my clients, it may be people that I serve on committees with. I don't do it looking for the reward, but I do it to maintain a standard that I have been raised and trained to adhere to. And the inevitable result is that people, and sometimes it's even what you draft. You know, it lands on a certain desk and it opens doors because somebody's like, who wrote this thing? Oh, wow. You know, and
the quality.
The quality of what your research, the courtesy in your tone, in how you have communicated your position, all these things. So, and then also realize that, for instance, cases are reported, your name appears. These days, we are happy to have, we are fortunate to have all these law platform and the rest online. So there is a certain byproduct. You may not set out to tout your services, but one way or the other, it will come to somebody's attention. It may start organically, but if you also want to be deliberate about your branding, there are legitimate spaces where you are allowed to do that without disadvantaging your colleague lawyer who would not have the same platform, for instance, to sit on a TV station or at a radio station and tout yourself or be touted as a legal luminary and to play to the court of public opinion. You see, so these Chambers and Partners, Martindale Habel, I think, Legal 500, Who's Who Legal, they are legitimate organizations whose business it is to gather data on lawyers and the work that they have done, and how they have set themselves apart. And they verify these things. And even though it starts off as a place where fellow lawyers may go, these days clients are also aware because, you know, there are sometimes law firms themselves are clients. So there are legitimate ways to brand yourself without writing your name and your practice areas on your car, for instance, Victoria Barth, experienced lawyer, or big billboard trained in so and so. You know, having said that, also, I think that we still need to look at our laws on the use of social media. You know, for instance, LinkedIn is considered as social media where information that you are allowed to put on your website as a lawyer, you are not permitted to put there. And I think that some of those things need to be relooked at. Because it appears that we just lumped Twitter and everything together. But LinkedIn is a professional, platform. So I'm not completely conservative to the extent where I've shut my eyes to where the world is headed. And the fact that sometimes the global world wants a recommendation and they can't find you because they don't know of your website.
Yeah.
So these are things that we have to look at. But one always has to maintain a fine balance between not deliberately going out there and selling your services, as it were.
Yes. Don't go near. Miss Barth, leadership at the bar. You did mention that as part of the grooming strategy here at the firm that you serve at, it has been involvement, an intentional involvement in activities of the Ghana Bar Association. Congratulations, you filed your nomination for the position of Vice President of the Bar.
Thank you. I hope you'll be congratulating me soon.
Yes.
That's my prayer.
We hope so. We also, Ms. Barth, the question then I would ask is why Vice President and not President? And I ask this because in recent times I've been exposed to work settings where I worked under someone who was a deputy, all right, and I realized that the deputy is as useful as the substantive officer makes him or her, and so if the focus or the intention is really to make an impact, then you want to then vie for the substantive role where you have the power, you have the mandate. And so the question then is, why Vice, not President?
Well, I think, first of all, let me say, while, yes, the deputy may be impactful to the extent that the substantive makes room, it doesn't also mean that a deputy is entirely powerless to drive change, even from the position of a deputy. Now, for me, I had to prayerfully consider a lot of things. I don't take any position, any executive position with a GBA lightly. It's an awesome responsibility to be able to serve your peers and members of your chosen profession. And as I said earlier, when I take on a task, I like to do it and do it well. Where I am in my life now, if you look at the work of a bar president, it is essentially a full-time job. I mean, even the vice president to a large extent. And I'm not in a position to commit to be the bar president. Currently. One, for financial reasons, which is a real issue, because if I'm going to dedicate so much of my time to be the CEO of the GBA, it means that I'll have to cut off certain income earning activities that I'm involved in. And I'm not able to do that. And I'm being honest about that. Again, more importantly, I like to be fully prepared when I'm walking into situations. And I know there are studies that I've read that say that women will always hesitate until they can tick all the boxes, whereas a man who is 60% qualified will just launch into the process. That may well be so. But I'm aware of the awesome responsibility of getting in there and holding the door open for many more women to come up. And I want to get it right. And that means that for someone like me who has not been on council or been part of the national executive before, I want to get in there and understand the dynamics on the ground, forge stronger relationships. Have a better grasp of what it is as a president I will be doing to foster the advancement of the objectives of the GBA. It doesn't mean that the vice presidential role is any less, that you can just take up. But even when I didn't have an executive position, I've always availed myself to serve the bar in whatever capacity I've been called upon to serve. I've done work on committees. I've served as a rapporteur. I've contributed ideas. I have mentored or advised other lawyers to lend their support. But I believe that this season of being the vice for me is the grooming stage. And it's the mobilization stage, such that come the end of my term, God willing, when I'm elected, I will be fully ready, and God willing to declare whatever it is.
Notice is hereby given.
Well, those are your words. Those are your words. I wouldn't want the president to feel as if I'm usurping. No. Yes. So I am happy to take this approach. As it were, to understudy a president closely.
Yeah.
I want that experience before I venture to be a president of the bar myself. I want to work closely with the president of the bar and have a personal experience and feel of what happens there. My former boss, Justice Nana Megache, has been president of the bar before. Yeah. While I worked with him in the firm and I served as a secretary of the Continuing Legal Education Committee, then it's not the same as being his vice, deputizing for the president in his absence, having the opportunity to participate and engage with the regional bars or the regional executive closely.
Yeah.
You know, it is an experience that I am looking forward to and want to have and build before I put myself forward as a candidate for the presidency of the bar.
Very well understood. Very well understood. So, Ms. Barth, from where you sit,
yes,
the Ghana Bar Association, what are some of the things that you feel can be better, or the areas you feel need attention? The association is made up of, lawyers with varying years at the bar, from one who's 1 year at the bar to those who might be 30-something years at the bar. There are varying needs, varying interests. From where you sit, what would you say are some of those areas that you are drawn to paying attention to?
So for me, the bar, and I'm trying to pull up the GBA Constitution, the bar works through committees, much like a board of directors will have committees. And for me as a vice who is not in the driver's seat, who wants to avail her services across the committees of the bar to the extent that my president will allow, and to the extent that I can convince the president that I can make impact, my focus is going to be on committee work, among other things. And there are several committees, but there are some in particular that I hope to be given the opportunity to be more actively involved with. But I talk about committee work across the board. And if you've seen any of my flyers, there are three things that I want to bring to bear: integrity, inclusivity, and accountable leadership. And I'm not saying that those things do not exist in any measure at the bar currently, but I'm saying that we can certainly do more and we can do better. So when I talk about integrity in the work of the committee, I'm talking about diligence and transparency in how we do our work, both as a national executive and through our committees. When I sit because I sit on the board of a bank, which is a regulated financial institution, there's certain information that we have to publish on corporate governance. And I think we can adopt those learnings for our committees. I want to read an annual report for our committees that shows me how many meetings that committee held and which members attended those meetings, because we show that data in annual reports for banks. And yes, it's not just about meetings, but what are the terms of reference of the committee? What were the objectives that were set for the year? How far did we go in achieving it? We must begin to have measurable results. All right. So that's just generally. And then in the same way, even the executive itself, do we have a strategic plan in place over what period? And these days, I know that strategy must be agile because there are so many changes. If you look at the unprecedented inflation that we had recently, DDP and all those things coming along, I suppose if the bar had investments, it could also have suffered all this. So when you have a strategic plan, it may evolve. But as a bar, what is our strategy? What are our objectives? At the end of a year in the term of a president, assuming that the conventional 3 years is how long the president is going for, what have we achieved? There must be that kind of assessment when we come for conference, where we address on these were the strategic goals, these are our KPIs, this is where we have gone as a bar. So, for instance, if I'm on the committee for monitoring courts, and in 2022, I had the opportunity to address plenary at the GPA conference in Ho, and I had to deliver a paper on, I think, access to justice, the judge's role. And my take on that was the fact that, access to justice is so critical because it can make or break the democracy of a nation. When people are so aggrieved and they feel that they do not have any means of redress, or they even go to court and they are not getting justice, or they are not getting it quickly enough, there can be confusion and anarchy. So the judge's rule for me was this judge showing up on time, performing. And then it led me to the question of who is measuring their performance. Because if I go to a court and the judge doesn't sit on time, the judge doesn't deliver my rulings on time, the judge keeps adjourning cases, the judge can treat me anyhow. What that communicates to me is that there's nobody above the judge who's assessing their work on a periodical basis to say that, 50 cases were allocated to this court at the beginning of the year. They are still being handled. 5 or 10 have not gone off the list, and they have not progressed to a stage that shows that work has been done on them. Yet another court, 100 cases, they finished, another 100 have been added. They are on the same salary scale. You understand? Come promotion time, we see names coming out of the woodworks. The judges that we know that are working, not all of them are put up for promotion. What are the metrics? What is the basis? You understand? And as part of our objectives in the Constitution, we are supposed to concern ourselves with independence of judges and yes, all those matters. So if I have something to do with the committee monitoring the work of courts, we are going to gather data. I don't just want to go to bar conference and say the judge sitting in Takrady or in Sawem or Ho or Wa, when things are not going well. I want real cases. I want to have data that in the month or from January 2024 to March, this judge only sat at 9 a.m. on 5 occasions. And these are verifiable because especially in the courts where proceedings are now being recorded, we only need to look at the course list for that day. And ordinarily, if we followed it chronologically, or even when we print out, we'll see the first entry and we'll all see that it's at 10 a.m. And if that is consistent throughout, why is it that nothing is happening? We can post this data on our website. I mean, I'm still going to collaborate with members of the bar and members of committees to make these ideas fully fleshed out. But that's one of the things that I want to spearhead, where region by region, division by division, we deploy our lawyers. When you have cases there and you finish, upload the information for us, especially in the courts where we are having issues, so that when we are presenting this thing to the judiciary, that we have issues with this court, it's not personal. It's about data that we have gathered, showing that this judge is persistently sitting at a wrong time. It's not punctual. This judge is persistently not delivering rulings, even when submissions and all whatnot have been filed. This judge has judgments that have been outstanding for so long, and yet there's no dispensation that the person is ill or anything of the sort. We must begin to hold them accountable. The same for the leadership of the bar, which is why I said, what are the strategic objectives? What are our KPIs? When we come to you at the end of conference, what can we show you that we have achieved? So what gets measured gets done. And that has to be same when it comes to professional development. It's something that I'm involved with either through my teaching or because I lead in a firm. Now it is mandatory under the LI 2020-2423. And guidelines have been, I happen to serve on the committee that came up with the guidelines for the continuing professional development. So how are we going to make it possible? You talked about different categories of lawyers. Not everybody can afford very expensive training. We have to have engagement and look at how we ensure that there's access and that it is affordable. Must everybody congregate physically? Can we have effective online sessions that are less the cost of physical participation? All those are areas where one wants to make an input and an impact. Yes. So this is just a a tip of
Tip of the iceberg.
Yes, and since I'm vice president and I don't have policies too. Yes.
Thank you very much for sharing that, Ms. Barth. I just want to touch on one area. I consider myself a junior lawyer, all right, and I know amongst the issues or the challenges that junior lawyers grapple with really is the issue of remuneration. All right, I know a number of my colleagues who, as a result of poor remuneration at various firms that they've served at, end up having to make certain decisions. And so they move to certain places, not because they want to, but simply because, look, we're not being paid well. And we've also noticed that, yes, you might have a scale of fees, but then when it comes to the remuneration of junior lawyers, managing partners, heads of firms, it's left to their discretion to decide how much they want to give you. And so I do recall once I was having a conversation with a colleague of ours, and she indicated, look, her boss will give her money at his discretion. And so there's no certainty as to when she's gaining income. And sometimes it's as low as 500 Ghana cedis, you know. And so these are real issues that junior lawyers are facing. And I just wanted your take on it. If you are probably in favor of, we have scale of fees, maybe scale of remuneration for lawyers. And I mean, just on the subject, I just want your take and maybe some remarks on the subject.
All right. So it's a difficult question, not because I can't answer it, because it's an area that is not regulated in terms of how individual heads of chambers pay their lawyers.
Yeah.
You know, we have a minimum wage, but we don't have a minimum salary or remuneration fixed for lawyers in private practice. If you are looking at government institutions, it's easier to go and make a case. You know, I think it all starts with engagement and encouragement for lawyers to adhere to best practice. You know, we have a committee that assists the GLC when it comes to license renewal. That goes around to check if law firms have libraries and what's not. I want to believe that beyond that, they look at the working conditions. I'm not talking about money, but at least where the seating area, I mean, whether there's toilet facilities and all that. And if that's not part of it, then that's one area that when I have the opportunity to serve, we should be looking at. One of the things, for instance, that has become compulsory now for a law firm to have is a policy on sexual harassment. You know, so I'm saying when you go around inspecting all these things, ensure that there's a policy, ensure that there's a mechanism for applying that policy, which means there must be a visible means of ensuring that members of the firm know about the existence of the policy and have been made aware of it. I'm saying that as a bar, we must consider having a whistleblower mechanism where when there's sheer abuse going on and people cannot articulate it where they are, it can come to the attention of the leadership of the bar and they can protect the welfare of their members. Now, when it comes to the money conversation, it is about encouraging. Sometimes it is not born out of wickedness, even though there are those greedy, mean seniors who just, you know, will not treat their juniors well. But there are others also who have challenges and perhaps need to be assisted by some of the programs that the bar can run, you know, on effectively managing their firms and their finances and their, because yes, the scale of fees is there, but you see that it is subject to negotiation between you and your client. How many lawyers are able to, you know, really charge on the higher end of the scale, and how many members of our Ghanaian public can even afford some of the rates in our scale, looking at the economic situation that globally and recently we've all gone through. So I think it is a conversation to be had. Again, you recall that I said it was easy for me to follow Justice Amegache to some Okudzeto Associates because I knew that the man represented a certain kind of values or value system. As a junior, when you are picking a firm, you need, I know not everybody has the choice about these things, looking at the sheer numbers and what is available. But it also means that you have to be deliberate about your planning. Even before you exit the law school, where are you interning? Which seniors are you approaching to offer your services free? Because you know that that is a well-structured firm where if you are fortunate enough to be recruited, you be paid a decent, The other thing, again, comes down to your, however weak your negotiating position is, when you are entering into a firm, make sure that you have something in writing as to what you are entitled to, so that the senior is not just paying you at will, as and when it pleases them. They shouldn't be giving you 500 if they told you they'll pay you 1,000. Can you ensure that that is put in writing for you at the start? Otherwise, that should send certain signals, to you. And then for those setting up the law firms, like the ones that you are seeing, don't repeat what was done to you that was not right. So I certainly empathize with the host of young lawyers, some not even young in age, but young at the bar, but mature with families.
Precisely.
Who are really going through. But unfortunately, the bar doesn't have that reach to compel private heads of chambers, but we can encourage best practice. We can make juniors also aware of other options that they can avail themselves of, and better ways to negotiate, and perhaps when we begin to look at a system of commending law firms who have set a good example of taking, the welfare of their junior members seriously. It may be an honor role that other firms may aspire to become part of. Nobody is mentioning your name and saying I'm not doing it. But if we begin to recognize firms that have shown that, they take the welfare of their lawyers seriously, then at a certain point in time, people will aspire to join that list. So this is a conversation that must be ongoing.
Constant engagement.
Right, yes.
We'll move to the subject of arbitration, and then we'll touch on litigation, which is your calling. On arbitration, the question really is, what do you think are the maybe special skill sets that a lawyer must have to thrive in arbitration practice? I mean, it's an area that is growing, an alternative disputes resolution mechanism. There's more and more talk about it, and now you have more and more people joining arbitration chapters and all of that. And so, from your exposure experience, was there a special skill set, and what should the young lawyers start looking out for, arming themselves with?
Well, fortunately for most lawyers, the skills you acquire as a litigator are easily transferable and applicable, save that the arbitral process is not as acrimonious as litigation will be, but the same process of using witness statements, filing claims and defenses, pertains in arbitration as well. Cross-examination happens there as well. So those very skills of advocacy and your understanding of substantive and procedural law is going to be very key, because over there you're now working with the law of the arbitration agreement, then the law of the actual contract in which the arbitration agreement is embedded, the law of the seat, the rules of the institution that is administering. So you are going to have to be someone who pays attention to all these things and has an appreciation of the rules that underpin the arbitral process. Again, we come back to hard work, we come back to diligence and learning, because with every arbitral institution that you deal with, you have to learn their rules. You also have to find out about previous decisions in different jurisdictions, because arbitration, once you are done with it, you also have to enforce, right? And there are treaties that affect how you are able to enforce in different countries where the resources or the assets of the party who has lost are located and all that. So your knowledge of substantive and procedural law are still going to be very, very relevant. But you also have to get exposure to observing the arbitral process itself.
Yeah.
And so you attach yourself to a senior or a lawyer who you know who is doing that, or you may even, based, of course, on your capacity building, serve as a secretary to the arbitral tribunal, or assist an arbitrator who will take you along to observe, subject to the consent of the parties to the arbitration, so that you get a first-hand. And then training, you have to go through training. You know, quite a number are organized by the Ghana Arbitration Center in collaboration with lawyers who are seasoned in the arbitral in the practice of arbitration.
Yeah.
So you get that training. Sometimes you get the opportunity to do mock arbitrations. And then reading, there are a lot of texts and materials. They join the associations as well, because they are constantly teaching and, you know,
exposing you to.
Exactly. So one has to be deliberate about developing themselves as an arbitration practitioner. There's also mediation. All of them are under yes. And these days, when people say arbitration, it looks like they are roping in mediation and all
as
that.
well.
But mediation is conciliatory, and the mediator doesn't have any coercive powers to make binding orders. That's one fundamental difference between the two.
So this is about litigation. we'll dwell a bit there as we round off.
Manson.
And what are your thoughts on moving or opposing a motion effectively and convincingly? All right, you filed your motion, supporting affidavits, your exhibits. You might have the opportunity to argue it out in court on your feet, or the judge will say, look, everything is on paper, and so I'll make a determination. From your experience, 22 years, what can you share with us?
Moving a motion, again, just as you distinguish, there are certain applications that go along with statements of case. And the whole rationale for that sort of application, for instance, like an interlocutory injunction application, was that when you have put all that together, the judge will simply come and give a ruling, having taken that into consideration. Depending on which judge you appear before, they will still sometimes ask you to address them. And as an advocate, the key thing is to make sure that you are communicating your strongest points first. Hopefully in your motion paper, supporting affidavit, and statement of case, if applicable, you would have set out the background facts concisely, so that there's no confusion in the mind of the trier of fact, what the facts are, at least from your perspective. And having done that, you would have highlighted the facts that are not in dispute, which are in your favor, and what the law says about that, you know. And so you would have put your authority there to so the facts, the evidence, the undisputed facts which work in your favor, even the evidence that appears to work against you, if you have an answer to it, you have put that, and now you have added authorities to show why the court must rule in your favor. And especially if they are binding authorities, you want to urge them strongly that given this scenario and given the evidence and given what the law says about these sets of facts, you must rule in my favor. So it is the order of your presentation is key. And the precision of the authorities that you use. It's not about lumping so many in the one, maximum two, which are really on point and which are going to be difficult for your opponent to challenge. And in doing all that, you are anticipating the arguments from the opposing side, which is why I said where even the evidence appears to be against you, you must deal with it. You don't shy away from it. So you start with what makes your case compelling before you deal with. Otherwise, you end up hammering and repeating that which you need to be getting out of the mind of the judge. So your choice of words is also important. I always tell my students we're in the business of persuasion. So, right? And that is why I say that even when the process is prepared, how it is formatted, how well the font size and everything, you've started selling the argument through the form in which it is appealing, it's attractive. It says, read me, you see. And then you have set it out beautifully, can be understood. The law, the citation and everything is there. The dictum that you want the judge to rely on, you have lifted it and put it there as briefly as possible, but telling him at what page they may find this particular piece of evidence if you have exhibited a ruling, or make it easy and pleasurable for whoever is reading it, so that they become more inclined to accept what it is you are saying. I mean, granted that you can do all this and then you still have a judge refusing, but you want to put your best foot forward. Yes. So master the facts, the evidence, the applicable law, and then present it in a convincing and engaging manner. Yes.
Can you touch on some, what in your opinion really are some of the mistakes that litigation lawyers make when they are conducting cases that we should probably look out for?
Okay, so I think it starts right from the pleading stage. How well you draft your pleadings is, I think, determines maybe 60% of your chance of winning the case, because you are bound by your pleadings once you file them, and whatever evidence you are going to be allowed to adduce is circumscribed within the four corners of your pleadings. And so you find that some people tell half a story, some people just deny, do not set out what is the basis for the denial. And then when it comes time for witness statements, they have issues because objection. You didn't plead this. You didn't plead that. Again, some people also overplead. They plead evidence. And sometimes it's not their fault. It's a function of the judge that they appear before, who seems to think that pleadings must be loaded with all the evidence. But most of the significant errors that I have observed is during the cross-examination stage, where people are conducting examination in chief instead of cross-examination. I mean, if you have filed a case and you are saying that, I'm saying that you don't own land, why am I now coming to ask you how you acquired it? I should be telling you that this land was acquired by my client. This is the evidence of the acquisition. You can see that it was registered. You can see that they have put structures on it. I should be putting my case across to you, and in the process undermining within the bounds of the law, not fabricating evidence, but undermining what clearly shows me that you are not somebody who acquired a bona fide interest in. But you find people saying, you say so and so, why? Why are you going to ask the person? So you've just opened the door. No. Tell me everything that makes it. Or for instance, there's you are seeking to recover lost profits from me. And in your witness statement, you have not adduced any evidence to show that you indeed would have made that profit. Then I ask you, how do you know you that? I will not ask you that question. In fact, all I need do is tell you that it is not correct that you are entitled to any, at maximum, I may even choose not to cross-examine you on it if I have denied it in the pleadings, because then the burden is on you.
It's on you to prove.
And if you haven't brought anything, that's the end of the matter.
Door closed.
But no, we must put. So I put it to you, I put it to you. And that's another thing I teach my students not to say, I put it to you.
I put it to you.
Yes.
Oh, this is right.
It is so, I know some people go to law school for the, for the opportunity to put, but it is dated. And it shows your hand even before you do it. You can ask a question without that phrase and it serves the purpose effectively. Yes.
I'm sure a lot of people will be disappointed.
Well, I sometimes the judges may say put it, but they are also coming from a certain era. But when you look at texts on advocacy that are coming out in recent times, it doesn't add or take anything. Yes, because all I'm saying is that as far as I'm concerned, I'm telling you this phone is not yours. It is not yours, is it? Must I say I put it to you that it is not yours? It's just superfluous.
All right.
Yes.
Ms. Barth, thank you very much. We want to enter into briefly some advice for the young lawyers. All right. Some advice for the young lawyers. I would ask a question on specialization. I mean, for you, following your strengths, you are very clear on where you wanted to go to. And along the lines, I mean, you expanded your tentacles. Wings were able to fly. For a lawyer, youngster who's struggling to figure out, where do I specialize in? What would be your advice on how to approach such a decision?
I'd say give yourself room to explore.
Okay.
So for instance, you're not going to do pupillage. There are one or two things you think you are interested in. And people have all kinds of reasons why they are attracted to different areas of practice. Sometimes people perceive it as, classy, or I see this group of lawyers, they are flying here and there for meetings, that's what appeals to you.
Yeah.
But is that what really fulfills and drives you?
Yeah.
Is that what you are best suited to do as a lawyer? That's a question you have to ask yourself. But we also don't live on passion alone.
Yeah.
It must generate revenue for you. But I think that give yourself the grace of 2-3 years of dabbling into different areas. For instance, if you are doing a pupillage and you have the opportunity to be rotated from the litigation practice to the corporate practice, and corporate divides itself into so many things.
Yeah.
So you get a taste, and then you have a better sense, not a complete sense, a better sense of what it is you are interested in and what it is may be in high demand in terms of what the market needs. That must also feed into your decision to go into a particular area of practice, because if you go and study about beds and nobody has any cases on beds, yes, you may write publications for us for the moment, but if your goal is to use it, for instance, in courtroom practice or in transactions, then perhaps you should be looking at, budgets when they are read to see where infrastructural development is going. You must be looking at, all kinds of papers from World Economic Forum. See where the world is going. I mean, these days also with AI and all that, you have to look at the future of work in the next 5 to 10 years and whether what you choose will still be relevant. So relevance, your own aptitude and ability, passion, and then, of course, revenue. Because you can't just be happy and drink water unless it's additions. We'll
come to that before we end our episode. And so relevance, aptitude, revenue comes down.
Yeah, and as a passion.
And passion as well.
Yeah, passion. You need that for the down times because that's what will keep you, at
going.
it. Yes, there must be something at the core that inspires you in that chosen field. So you have to look at all that. Yes, it's not exhaustive, but that is something that one would want to consider in deciding to specialize in an area.
All right, so Ms. Barth, I'll ask this question: if you had
Yes.
the ability to influence what the law school curriculum was, what would be some of the things that you probably add or subtract, if any? Do you think it can be improved? Do you think it should be steered in a certain direction? What are your thoughts on that?
Well, I definitely think it can be improved. I mean, there are different courses that other jurisdictions handle, even though I would not be so quick to throw out what we are doing, but I would alter the approach of instruction. And I'll start with my own subject. You see, we have constraints. For instance, last year, the class that I was teaching, and there were 2 streams.
Yeah.
And so this is just group B. It was over 250 of them.
Wow.
And advocacy is supposed to be a practical course where I should be able to walk into the room and give a scenario or even bring a make-believe client, so hold a law clinic, have my students interview that client and see how much relevant information they can gather for purposes of, say, drafting a pleading, so that one can see their interviewing skills at play, their listening skills at play, their communication skills at play. But when you have 250 students, how are you going to do that?
Yeah.
You know, you have moot sessions where it's supposed to be 2 people, ideally, applicant, respondent, appellant, respondent.
Yeah.
You know, arguing an appeal or moving and opposing a motion. These days, you have to find sometimes 10 people on one side as applicants, and you have to divide. Somebody will announce the parties and say what the motion is, and then another person has to argue one ground. We have so that everybody will have the opportunity of standing up and hearing their own voice and addressing the panel. So it's become more theoretical than practical. The same thing translates at the end into how they are assessed. Because if you had the opportunity to do mock cross-examinations, the kind of exam question that you would ask would be a fact pattern and the position of a party, and what kind of cross-examination would you do to advance the case. That would be an example. But you find more questions like, tell us about the limitations of re-examination or whatever, because you've not had room to teach it as practically as you would want to be asking those kinds of questions. Because who comes into practice to describe cross-examination? You come into practice to do.
Yeah.
So we have relevant subjects, but there are new subjects that are coming up that involve technological use. I mean, here we don't do open book exams, but at the end of the day now, everything you need to know, almost, AI is telling you. So I, for instance, am a firm believer in open book exams for law school. I don't know if we will ever get there, but I believe that at that point, when you don't know and you haven't learned, it's beyond the what is and when or how. It's applying the reasoning. It's about showing analytical and strategic thinking in how you deal with the subject matter that you have been taught. So I haven't paid particular attention to the subjects that I would like to suggest, but definitely for me, opinion writing, you know, and subjects that promote analytical thinking. And also touch on it. Perhaps we can also enhance our courses on ADR. That's one area to look at, because we have alternative dispute resolution embedded in that. There's arbitration mediation. So we can look at expanding that. But
Ms. Barth, I'll conclude with this final question. You made mention you belong to a Christian firm, and at a point you mentioned that you had prayerfully approached a certain crucial decision of your life. What what has been the impact of your faith on your profession?
It's been everything. It's been everything. My faith in God and everything I do and every decision I make is intertwined. Who I chose to marry, where I choose to work, where I choose to live, what I choose to do, I take it all to God. How I conduct my cases, everything I do has to be about, is this honoring? And that keeps me centered because it goes beyond what my ethical code is telling me. I have a higher power to render accounts to. And that is who I look at. I don't always get it right. And I seek his forgiveness and the forgiveness of whoever I have wronged. But I believe in a God whose son is Jesus Christ and the Holy Spirit. And I believe in the word of God and it regulates my life. So everything I do, at the end of the day, it has to be for the glory of God. And so any opportunity I miss also, I understand that it is not in his will for me at that time. But when he opens the door and he makes the way,
You enter.
I will enter with alacrity and he will give me the resource. He will grant me the wisdom. He will give me the direction and the helpers to make sure that, it is done to the glory of his name. Yes.
Thank you so much for sharing. And thank you very much for your time as well.
It's a pleasure.
Ladies and gents, we've come to the end of our conversation. It's been a delightful conversation. Do look out for our other episodes. And I do hope that you draw a lot from this conversation I've had with Mrs. Victoria Barth. Thank you and see you.